สวัสดีค่ะพบกับเพจห่วงใยไทย Business อีกครั้งหนึ่งในช่วงของ Legal in Action นะคะวันนี้นอกจากน่าจะมีไม่กี่นาทีนะคะที่เราจะพูดภาษาไทยแต่ว่าที่เหลือจะขออนุญาตใช้ภาษาอังกฤษนะคะเพราะว่าวันนี้หัวข้อของเราซึ่งอย่างที่ได้ไปแจ้งนะคะใน Facebook ว่ามีคนสอบถามมาเยอะมากเลยเพราะว่าช่วงนี้เราอาจจะได้ยินข่าวนะคะซึ่งที่จริงเรื่องนี้ก็คิดว่าไม่ใช่เรื่องใหม่นะคะถามว่า FCPA คืออะไรนะคะก็เลยเป็นโอกาสอันดีนะคะที่วันนี้เรามาฟังเรียกว่าผู้เชี่ยวชาญเป็น expert แล้วก็มีประสบการณ์ที่จริงในหัวข้อนี้นะคะเราเคยจัดไปครั้งหนึ่งเมื่อปีที่แล้วนะคะตอนนั้นมีผู้แทนจากสำนักงานปปช.เลยที่มาพูดคุยกับเรานะคะซึ่งก็เป็นหัวข้อในเรื่องของอะไรคือมาตรการควบคุมภายในที่เหมาะสมนะคะประมาณเดือนกรกฎาคมแล้วก็มีแต่เรื่องของ FCPA หรือว่าUK Anti-Bribery Act นะคะไปส่วนหนึ่งนะคะแต่ว่าวันนี้ฉันเรียกว่าขอเชิญทางที่ปรึกษากฎหมายสำนักงานที่ปรึกษากฎหมายที่เรียกว่าเป็นผู้เชี่ยวชาญแล้วก็เขาก็เนื่องจากเป็นกฎหมายของเขานะคะเพราะฉะนั้นเขาคงจะมีอะไรมาแชร์กับเราเยอะเลยนะคะ Let's me introduce the expert and the team from Jones Day and because today's topics I have received many questions asking what is the FCPA so it's a good opportunity, in fact, to hear from the real expert both on FCPA, which is on the US side, and also UK Anti-Bribery Act. So from Jones Day, we have. I'll go by the pictures that I've seen on the screen. Starting with HARRIET TERRITT. Hello. สวัสดีค่ะ HARRIET is partner in Jones Day London office. Then Chris Pelham. Chris is the op counsel from Shanghai. And last but not least, in case we will have a few more, Matt Skinner, who is partner in Singapore office. So hi everyone. And for the audience who has questions, you can type those questions on Facebook and you can either type in Thai or in English and then I'll get the speakers to answer those questions if we do have time. So after my very brief introduction, you guys feel free to introduce yourself more.
Okay, thank you, PB. I guess Harriet, we'll start with you.
So hi, good afternoon, everyone. Thank you very much for this kind invitation. Really, I'm happy to sort of just go straight in. My name's Harriet. I'm based in London and I specialise particularly in the UK Bribery Act, one of the laws that we're going to be talking about that has a broad extraterritorial effect and therefore may be relevant and interesting, particularly to your international operations. I would maybe just say one thing, which is just to echo, we're very conscious that all of you have given your time. We want to make this as useful as possible. So if you do have questions, if anything we explain isn't clear, please do ask and we'll do our best to clear that up.
Thank you, Harriet.
Matt, should we go with you first?
Sure, just very quickly. Hi there, everybody. Very pleased to be presenting today. We hope it's as useful as possible. I am a partner based in the Singapore office of Jones Day, which is a regional office. We essentially cover Southeast Asia. And in addition to helping clients with disputes and contentious related matters, we help them with these types of investigations arising under either the FCPA or the Bribery Act, or just internal investigations that clients are wanting to do in order to ascertain whether there's any corruption issues or fraud issues or essentially conduct that is not consistent with their business practices. Then we will go in and help with that. Looking forward to receiving your questions and hope this is helpful.
Given that you are very close to Thailand, next time you do this in Thai, right?
I look forward to that.
So Chris.
Yeah, thanks, PB. So my name is Chris Pelham. I'm another counsel in our Shanghai office. Jones Day has several offices here in China. We assist clients with FCPA counseling, internal investigations, as well as in the worst case scenarios, dealing directly with prosecutors and regulators in the US. So as Matt and Harriet said, thank you very much for having us, and we hope to be as informative and participative as we can today. Thank you.
Thank you. So now I will turn the floor to you all, because I know from receiving the pack that we have a lot to tell the audience. Please go ahead.
Okay, thanks, PB. Harriet, I guess we'll turn to you for the first part of the discussion.
Thanks, Chris. And if we could go one slide forward, please. We thought we would start by trying to put the points we want to discuss into a global context. And I think many of you may have seen this map before. This is something called the Global Corruption Perceptions Index. It's published annually by a global organization called Transparency International. And what it seeks to do is rank countries and territories based on how corrupt a country's public sector is perceived to be. And that perception is a combination of experts, business people like yourselves, as well as private individuals. So it's a composite index. It's not one single measure or survey. It actually takes about 13 different measures, and it collects those every year and ranks them. So the CPI is really considered to be one of the most widely used indicators of corruption on a global basis. One point that's important to emphasize is this index is based on the perception of corruption. Why is that? Well, actually, you know, corruption is by its nature something that tends to be hidden. So what the authors of this survey has found over the years is actually the most reliable indicator is what individual business people, private individuals perceive as the risk in their day-to-day business. You know, I think there's a couple of points to show on this map. One is there is no country in the world that is free from risk of corruption. So this is not about saying that some countries do things particularly well and others particularly badly. This is a global risk that exists everywhere in the world that you may do business. However, I think what it also shows quite clearly, and you can see the lighter colors are where the risk of corruption is perceived to be lower, and the much darker colors are where the risk is seen to be much higher, is what it gives international business people is a fairly clear indicator of where in the world their business is at the greatest risk, and where therefore they should be focusing their time, their energy and resources. So it's a useful resource to look at when you're coming up with both your assessment of risk and also your strategy for dealing with that risk. If we could go forward, please, Chris. Thanks. So today we're going to be focusing mainly on two laws. The United States Foreign Corrupt Practices Act. It's a law that's existed really since the mid-70s, but it has a very long track record, as Chris will explain, both of applying to businesses outside the United States with a very strong culture of enforcement and significant fines that have been levied against international businesses. We're also going to talk about the United Kingdom UK Bribery Act, a much more recent piece of legislation, which on its face is even broader in scope than the US FCPA. But as we'll come on to talk about at the moment, we haven't yet seen the same track record of enforcement that would necessarily categorize it to the same level of the FCPA. But what we really wanted to say in this first piece is this is not just a US law or a UK law issue. This is really a global issue. There are many countries around the world in the last few years who have radically updated their anti-corruption programs, bringing more types of conduct within them, making more types of conduct illegal. And at the same time, we have seen enforcement and cooperation and coordinators between global regulators increase. And we'll give you some practical examples of that as we go through. So I think kind of there are some countries that are worth pointing out here. You know, Germany, the Netherlands, France, many European countries have updated their own anti-corruption laws, but actually it's places like Russia, Brazil, and China where I think historically people might have considered those to be less significant risks of enforcement, now are much higher on the sort of concerns of executives as places where if their companies become involved in corrupt conduct, they are at much greater risk of enforcement. So whilst we're going to focus on 2 countries today, our message is really this is a global issue. And if you have an issue under the US FCPA or the UKBA, you almost certainly will have an issue under other laws as well. If we could go to the next slide. So I like to start these presentations with a literary quote. I hope you will forgive me for that. This is from a famous English author, George Bernard Shaw, who wrote Pygmalion, which is, if anyone has seen the film My Fair Lady, that's what that story is based on. But he was asked to describe really the relationship between the United States and Great Britain. And he came up with this one, that we are 2 nations who are divided by our common language and our common history. If we could go forward, please, Chris. And really why I picked that as a start is I do think it's interesting to look from a sort of legal perspective at how the US on the one hand and the UK on the other have approached this issue of managing global anti-corruption risk. And really the message here is it's important not just to look at the wording of the law, but also to look at the trends of enforcement, the wish of the country to enforce its laws, and its sort of budgeting and ability to do that. So if you look at the wording of the FCPA, it is in many ways a much more limited piece of legislation. There are more potential exclusions from liability, and you contrast that with the UK Bribery Act, which has an incredibly wide scope, broad extraterritorial jurisdiction, and really no exemptions to speak of. But in practice, the FCPA at the moment is actively being enforced, including, as we will hear, from countries that have no obvious connection to the US. The fines are large, and the prosecutors certainly consider themselves to be fearsome, as Chris and Matt can talk to you more about. You know, in contrast, in the UK, the enforcement at the moment has largely focused on significant connections to the UK, and the enforcement record is more mixed. One thing I will say is, you know, the UK Bribery Act is a comparatively recent law. It was passed and came into force, you know, a number of years ago, but really only a short period ago. And that's important because actually the enforcement of the FCPA didn't really start to take off until about 20 years after the law was passed. So these things do take a little bit of time. And I wouldn't be surprised if I or another younger partner at Jones Day was presenting in 10 years' time, they might be telling you something different. So it's definitely something to watch.
Okay, well, thanks, Harriet. So as Harriet said, the FCPA on the US side is a rather robustly enforced and utilized statute. So the reason why the FCPA is so important for many of our clients and for multinational companies around the world is because, as Harriet said, the US Department of Justice devotes a pretty significant amount of resources to enforcing the FCPA. It has a dedicated team of prosecutors who only focus on this statute, as well as FBI agents who only focus on assisting those prosecutors. So that means that the US tends to prioritize and take very seriously FCPA enforcement and FCPA cases. So we'll start at the basics. What does the FCPA actually prohibit? Well, how does the statute work? So it only criminalizes bribery of public officials. So it only applies to the movement or the attempted movement of things of value, so cash or other benefits, specifically to public officials. Now, sometimes that can go through other channels, sometimes that can be done through third parties, but the ultimate recipient or intended recipient has to be someone who is a public official. We'll talk more about that term later, because that doesn't just mean someone who works for the government. It might also apply to someone who works for a company that is seen as an instrumentality, right? Or an arm of the government. So even private employees in certain circumstances can be considered public officials for the purposes of the FCPA. The FCPA has two major prohibition categories. The first is anti-bribery. This is the one that naturally people think of. And so that criminalizes a corrupt payment to a public official for the purpose of obtaining or retaining business. So the easy example, of course, is giving cash to a public official in order to get business. But that model is just one part of the anti-bribery provisions. As we'll talk about later, the FCPA targets lots of different types of provisions here under the anti-bribery component. The other part of the FCPA is the books and records provision. This is important for companies that issue shares, that issue securities in the United States, ones who are either publicly listed or raise money through over-the-counter public share markets in the US. Those companies that raise money in this way through US markets must also comply with the books and records requirements of the FCPA, which require that that accounting be accurate and that those companies have a system of internal controls in order to ensure that that accounting is accurate and that the money within the company is being spent in a compliant manner. The books and records provision, again, only applies to companies that raise capital through securities in the US. But as we'll talk about, that becomes important for non-US companies who may be affiliated with US listed companies, for example, through a joint venture or through a subsidiary. So these are the key elements of the FCPA. The covered person refers to who is actually under the statute's control. We'll talk about who a covered person is. A US company is the obvious and easy one, but there are other entities and individuals who would fall within the statute's ambit. Corrupt intent. So the FCPA prohibits giving something with the intent to have the recipient act outside of their official duties, right? So in other words, is it done with the intention of getting that public official to do something that they should not do in order to get business for the bribing party? We'll talk about how it is that DOJ determines that state of mind. Does the individual, does the defendant directly or indirectly offer, promise, or give something of value? So you need the actual transfer of the thing of value to the recipient. That's what the FCPA is going to target. We already talked about government official. And then finally, the intention has to be to obtain or retain business. There has to be an ultimate commercial purpose for something to be counted under the FCPA. Now, some important principles. As we discussed, the FCPA prohibits not just the cash bribe, but anything of value that is provided to a public official, a government official. That can include travel, an internship for someone's son or daughter, maybe a nice restaurant dinner. And we'll look at some examples. The FCPA has no minimum. There's no de minimis exception. That means that the FCPA, even if the value is $5, 10 US dollars, if the other elements are satisfied, that's sufficient to trigger FCPA enforcement. Now, of course, DOJ doesn't really waste its time on such small cases, but it's important to know that there is no official minimum. And then finally, the other point that I would emphasize is that there are few effective defenses to the FCPA. The reason we say that is because the FCPA has no exception based on the character of the market. So the fact that this is common practice, the fact that a public official required a provision to be made or a bribe to be made, these are not defenses. As long as a payment went and the other 5 elements are met, or the other 4 elements are met, then there's an FCPA issue. So who's covered by the FCPA? The easiest category, of course, would be US citizens and permanent residents, as well as companies that are organized or located in the US. That's easy. But non-US companies also fall within the FCPA if other if other requirements are satisfied. So if I am a subsidiary of a US company, I am covered by the FCPA. If I'm a non-US company that raises capital within the US through shares and securities, I am under the FCPA. If I'm a non-US citizen, but I'm an officer or director or an employee of a covered person, then I fall within the FCPA. And probably the broadest category is persons acting within US territory. So this has happened in the past. If I'm a non-US company and I am not a subsidiary of a US company and I don't raise money on the US share markets, I can still fall within the FCPA if I carry out some part of the violation in the US territory. And you might be thinking, well, okay, that means you have to go to the US and do the bribe there. Well, yes, that would count, but a lot of other things count. And so DOJ has, for example, used situations where maybe I meet with my foreign official somewhere in the US to discuss the bribe, or I use a US bank to carry out the bribe, or a US correspondent bank to carry out the bribe, or I use emails, or I make phone calls that pass through US servers or US wires. That can generate a sufficient geographical connection. The important thing to keep in mind here is that US prosecutors tend to take a very aggressive and broad approach to jurisdiction. And lots of non-US companies that have nothing to do with the US capital markets find themselves in the FCPA for these reasons. So corrupt intent, I'll just address briefly. What is a corrupt intent? Well, it's an intent to cause the recipient to misuse or abuse their official position. So if I have an inspector coming to my factory and the inspector says, you know what, I can help you out here if you give me a little bit of extra on the side, and I pay this inspector, that's likely done with corrupt intent because it's likely to be found by DOJ and a court that this inspector is not correctly applying their official position. They're acting beyond their official position to get a personal favor from you in the exchange for business. So the corrupt intent is required. So what's evidence of a corrupt intent? It might be an agreement regarding a quid pro quo. That's going to be very easy. If a public official is acting contrary to what the law allows, that's going to be easy as well. Facilitating payments are not covered under the FCPA. I'm not going to spend much time discussing facilitating payments. Just know that the DOJ recognized that little payments that are just meant to ease the flow of business, even when they're made to a public official, are not covered under the FCPA. The problem with that exception is that no one is very clear on what the dividing line is between a corrupt payment and a facilitating payment. So I'll just say briefly that there is this additional category that's an exception to the FCPA. Very briefly, as we discussed, what is a thing of value? Easily includes cash, but it can also include things like loans or charitable contributions. It can include excessive hospitality. It can include stock or interest in a joint venture or another entity. It can include real estate. If I undersell my house to a public official, that can be a thing of value. If I give a job to a public official's niece or nephew who really wants to work at my company, that can be a thing of value. So it's important to keep in mind that this is a very broad category. And then finally, as we mentioned, what is a foreign official? A foreign official is going to be anybody who works for government. That's easy, but also anyone who works for a government instrumentality. By the way, this is not a hard and fixed category. And we've seen examples of where DOJ has considered a company that only has a minority ownership by the government to be an instrumentality, right? Because it could be that the government gets to appoint 2 or 3 members of the board of directors. It could be that the government has supervisory power over your budgeting and spending. It could be that the government provides all of the land and the capital that the company uses. It's very difficult to tell sometimes beforehand what DOJ will consider an instrumentality of a foreign government or of a government without knowing what all the facts are. So just know that this can be a very broad and fluid category. And so obtaining and retaining business, as we discussed, the payment needs to be made for the purpose of getting business or keeping business. The business does not need to be specified in a contract, and the advantage can be anything. The business advantage can be anything, not necessarily just favors from the government. So an easy example would be winning a procurement contract, but it could also be things like getting access to non-public bid information, getting better tax treatment, advantageous tax treatment, getting a hard to obtain license, right, or an inspection pass. All of that can be considered obtaining or retaining business. I won't spend as much time on the books and records and internal controls component. Just know again that these apply to issuers, US issuers, and they require that the books and records, the accounting of US issuers, be accurate, and they completely describe the expenditures of the organization. The reason for the books and records provision is that DOJ had traditionally found that when companies made payments, bribe payments to government officials, they would record them as something else, like maybe record them as marketing or promotions or petty cash. So DOJ instituted this separate accounting category to try to catch that form of malfeasance. Internal controls, we're going to talk about a bit more in the presentation. All companies who are US issuers are required to have a sufficient system of internal controls to ensure that expenditures are appropriate and authorized. As you will hear me, Matt, and Harriet say shortly, this internal controls provision refers broadly to the maintenance of an effective internal compliance program. And all companies, whether they are US issuers or not, any company that is concerned about FCPA application should take seriously the requirement to have a good compliance program. And we'll talk more about that. Okay, Harriet, I turn to you.
Just before we move to UKBA, a few questions on FCPA, because when I compare that to Thai law and for the benefits of the audience, we do have National Anti-Corruption Commission, or NACC, which so to speak that they are in charge of all bribery and corruption issues. And we do have an SEC who actually regulates and be the authority regulator in charge of listed entities, and pretty much look into fiduciary duty and whether directors and management breach the provisions in the law, including governance matters. In that context, how would you compare with the Department of Justice and SEC of the US? Is that something similar?
Yeah, absolutely, PB. So we have a discussion later in the presentation about what Thai regulators have required in terms of maintaining good internal controls and good compliance with respect to anti-bribery. So absolutely, we will stress that for Thai companies, the Thai anti-bribery laws and the Thai requirements on compliance and effective and accurate record keeping are going to be very similar to the DOJ and SEC requirements. And in many of those ways, what we're finding is that a lot of our clients, wherever they are in the world, in certain jurisdictions, the requirements of their home enforcement authority, like in Thailand, and requirements under US and UK law are going to be overlapping. So it just makes sense to comply as broadly as possible.
Yeah, thank you. The next point that, in fact, I would like to make to the Thai audience is that when Chris referred to public officials under Thai laws, that will include the government officials and also officers or employees of state enterprise for sure. And in Thailand, we do have the budgetary act, which defines the nature of state enterprise. But it seems like the audience will have to be careful when DOJ look at who is or who could be considered public official, because it could be even broader.
Yeah, no, thank you, PB. And I completely agree. And actually, with DOJ will often look to see how an official is treated within their home jurisdiction, and they'll look to, as you mentioned, the law of the home jurisdiction to determine if someone is a public official. So it's likely that if the Thai category for public official is broad and someone will fall within it, it's likely DOJ will adopt the same view.
Okay, thank you. Please go ahead, Harriet.
Thanks, PB. Thank you, Chris. So we're going to turn now to the UK Bribery Act. And what I'm going to try and do is compare and contrast with the description that Chris has given of the FCPA, because the laws effectively seek to do the same thing. What the UK Bribery Act is aimed at is criminalising acts of bribery that have a connection to the UK. So it is important that there is some level of connection to the UK, although as we'll see, that level of connection can indeed be very minimal in the same way as it can in the US under the FCPA. The main difference is one that Chris has already highlighted. The scope of the UK Bribery Act is broader than just dealings with public officials. It applies to all dealings, commercial, business dealings. It applies in private life to any acts of bribery that have that connection. When you look at the legislation, I think it's easiest to sort of split the legislation into two parts and consider those parts separately and independently. The first part is what we call the general offences. Some people call them the principal offences, and they are your real basic bribery acts. So offering, promising, or giving someone a bribe, requesting or agreeing or actually receiving a bribe. So in the United Kingdom, differently from many other countries, the actual receipt of a bribe is a criminal offence as well. And then the third part, which is bribing a foreign, i.e. a non-UK public official. So if you, particularly where you're considering sort of issues under Thai law, if you had a situation where there was a transaction connected to the UK, so it was within scope for the Bribery Act, but actually the person or entity being bribed was a Thai public official, that would be potentially within scope of the UK Bribery Act. And that's a really important sort of idea to get your head around, because it feels instinctively like it should be a Thai only matter. The message here is this could have wider ramifications. Similarly to the FCPA, there is, for most of the offences, a requirement to intend to induce an improper performance by someone. So you have to, if you are offering a bribe to be within the scope of the Act, really intend to bring about some kind of improper performance, certainly for the main offence of offering a bribe, and similarly for receiving a bribe. You have to receive it with the intention of doing something that the person would not otherwise do in the normal performance of their duties. One point of difference, the test for bribing a non-UK public official is lower. It does not require improper performance. What it requires is an intention to influence the public official to do something different. So it's a lower test and therefore potentially much easier for transactions or activities to be caught within that. The last piece of the Bribery Act, the sort of second piece, is something called the corporate offence. And this was, when it was sort of first published in 2011, really a very radical way of trying to bring corporates and business organisations to account for bribery in the United Kingdom. And there's lots of sort of technical reasons why it's quite difficult as a matter of English law to find companies liable for actions that take place at a below board level. But similarly to many other jurisdictions, you know, a company is an embodiment of the acts of its directors. If the directors are not aware of issues or it takes place at a much lower level, it can be quite difficult to prove that the company itself should be guilty of this activity. And the corporate offence is the UK's attempt to meet that challenge. What the corporate offence does is it introduces a fairly radical new offence that only applies to commercial organisations, and it effectively makes them liable for bribery which is committed by their associates where they have failed to put adequate steps in place to manage the risk of that bribery. Now, I'm conscious that's quite a complicated concept. If we just move forward onto one slide, we'll talk a little bit about kind of what that means in practice. Thank you. So the first thing you need to know about the corporate offence is it's an unusual offence under English law because it's what we call a strict liability offence. That means that there is automatic liability if certain criteria are met. You do not need to go through the sort of normal process of did the action happen, was there an intention? There is one defence to an allegation of a breach of the corporate offence, and that is that the entity or the organisation had adequate procedures in place to prevent bribery by its associates. So again, you can see the sort of policy decision behind this offence is to really require affected businesses to look at their corporate criminal liability programmes to make sure that those are adequate. And even if an action of bribery happens that is potentially caught by the corporate offence, providing you have those adequate procedures, you will have a defence to the risk of liability. When we look at the scope of what's caught by the corporate offence, it's incredibly widely defined. So associated persons is really anyone who is performing a service for your business or organisation. So that's employees, it's your joint venture partners, it's your agents, it's your consultants, it's potentially even the suppliers you work with. So if any of those offers a bribe for or on behalf of an entity that is within scope of the offence, and I'll come on to jurisdiction in a minute, then you need to think very carefully about what is the risk that this person or entity offers a bribe on my behalf or for my benefit, and therefore exposes me to liability under the UK Bribery Act. It is important to say that there is still a requirement for a jurisdictional connection. The companies and entities that are caught by this corporate offence are those that are doing all or a part of their business in the UK. Now, that jurisdictional scope has not been tested yet. We don't really know what doing a part of business in the UK means. We think it means having, you know, some presence in the United Kingdom, but not necessarily a permanent establishment. And one of the things I will come on to talk about is if you are a Thai company that has a UK subsidiary, what does that mean for you? Because I think a lot of people worry that the corporate offence exposes the parent company to liability for the actions of the subsidiary. It's actually quite a lot more complicated than that, but generally I think we can give a good amount of assurance that providing your subsidiary acts, you know, as a normal subsidiary in a comparatively independent way, that liability should not flow back up to the parent company. But it's a key issue, so we'll talk about it in a bit more detail.
Thank you. Just one question on the criminal offence, like under UK Bribery Act. Are we talking about money penalty, or we are talking about both penalty and also like imprisonment?
So the penalties are, for a company, it's an unlimited fine. And as we'll come on to talk about, some of the fines have been very significant indeed. For an individual, there is the possibility of criminal penalties, so fines and jail times. One of the points that I probably should have made earlier is that if a company is found liable of the general offences, so the company offers a bribe or receives a bribe, there is also a possibility that the directors can be individually liable for that as well. So that's something we take very seriously, although it's quite a high barrier to get over as a matter of English law, which is why we have the corporate offence. Wherever there is a possibility of jail time or of individuals being debarred from acting as directors in future, it's something that our clients take very seriously.
Thank you.
So if we could go forward, Chris, please. So similarly to the FCPA, the UK has a very broad definition of what counts as a bribe. You know, obviously it includes all of the points we've sort of talked about here, and Chris has already really talked about. I mean, one thing I will just sort of maybe add on to Chris's analysis is whilst there are still some bribes that take place in the world with, you know, brown envelopes of cash are handed over, that is not really what the regulators are focused on now. The regulators have a very sophisticated view of what counts as a bribe. They are looking at, as we've talked about, influence and intention, and they look at the difference in many cases between the impact of the bribe on the recipient, you know, versus the impact on the individual. So it's not as simple as saying that $200 everywhere is okay, but anything below that, anything above that isn't, because what you have to do is look at it in the context of the country, the market, the sector that you are operating in, as to what risk there is that any payment or meal or hospitality or business trip could influence that recipient. So we'll talk about what that means in practice, but I think it's really just to build on what Chris has already said. And if we could go forward, please. So I've talked about this a little bit already. The one thing I want to sort of mention is people sometimes think that it's the corporate offence they need to worry about for extraterritorial jurisdiction. And it is, because if you are doing a part of your business in the UK, then you're going to be caught by the corporate offence. But I do want to emphasise the jurisdiction of the general offences is very broad indeed. So if any part of the acts or the omissions that lead up to the bribe take place within the United Kingdom, so England, Scotland, Wales or Northern Ireland, they are within scope for the UK Bribery Act. And if you think about what that means, you know, if you have an individual who's in the UK when this activity occurs, if you're using a UK bank account or email or other sort of information is passing through UK servers in a similar way to the US, all of that technically will bring the bribe within the scope of the UK Bribery Act. I should say that the UK regulator is fairly pragmatic about the matters that it chooses to enforce. If you had a matter that was really substantially Thai, all the connections were to Thailand, the parties were Thai, it just happened to be that the payment had passed through a UK bank, I think the prospect of the UK regulators thinking that was an appropriate matter for them to enforce as opposed to the Thai authorities is very limited. But you would expect that they would be supportive of and would provide assistance to the Thai authorities in respect of the parts that have come through the UK. But I do just want to emphasise that the legal scope is incredibly broad indeed, and therefore it's something you do need to think about, particularly if you have UK operations. And if you go forward, thanks, Chris. So the last thing I really wanted to do in this section was talk a little bit about the parent company liability, because it is a question that comes up, you know, many times. And you do need to think about this sort of matrix of, is it a general offence or a corporate offence? Who is involved in making the bribe? But I think the key point is that under the UK Bribery Act, parents are generally not liable for the activities of their subsidiary. You obviously need to look at how the subsidiary is run and managed. If the parent effectively controls the subsidiary, then you could see issues, but the whole point of having a subsidiary is a separate legal operation, and providing that's what happens in practice, I think your general position should be the parent is unlikely to be liable. If you look at the situation where a subsidiary has offered a bribe in its own conduct for its own business, the non-UK parent company would not be held liable for that activity under the UKBA. It cannot be held liable for the subsidiaries, the actions, only the subsidiary. You then look at the second box, which is where you have a slightly more complicated scenario where both the subsidiary and the parent may have been involved in the offering of a bribe. There you need to look at, has any part of the bribe taken place in the UK? If it has, the parent could be charged in its own right, because we're into that very broad territorial restriction, even though the UK parent is not present here. But the parent company would still not be liable for the subsidiary's actions, only its own actions. So that's one where the jurisdiction is broad, but you still don't see the subsidiary being, effectively the conduct being imputed to the parent. The last situation that I put in the orange box is obviously where the subsidiary offers a bribe on behalf of its non-UK parent company, or for the benefit of its non-UK parent company. And there you would have to look at, is the non-UK parent carrying on a business in the UK within the meaning of the corporate offence? And then there is definitely a risk that the non-UK parent could be liable in its own right under the corporate offence. But again, if the only UK activity is taking place in the subsidiary and the parent itself does not have, any part of its business separately from the UK subsidiary in the UK, you wouldn't be within the territorial jurisdiction. I'm conscious that's an incredibly complicated set of facts, and we cover them very quickly. So I think all I will say here is, if you ever find yourself in this situation, you need to think very carefully and get some good legal advice. But I think as a general position, you should assume that providing your UK subsidiary operates in a normal, broadly independent way, the parent company itself should not be liable for the subsidiary's actions. Mm-hmm. And if we could just go forward, Chris. So the last thing I really wanted to touch on here was kind of a very simplified comparison. This is something that maybe you can take away and look at your leisure, because it's, again, a lot of complicated words, but it's really to show you there are a lot of similarities between the FCPA and the UKBA, but also some key differences. The obvious one being that the UKBA applies to private commercial transactions, the FCPA does not. But as Chris has explained, because of the broad definition under the FCPA, that difference is not as extensive as you might think. There are no exceptions under the UKBA for facilitation payments or bona fide business exceptions. But again, as Chris has explained, the US interprets those exceptions very narrowly. So although there is a technical difference, practically, we're not so much sure there is. One thing that is different between the US and the UK is in the context of whistleblowing. The US for the last few years has run a very successful program encouraging people to report conduct that is a breach of the FCPA, and it offers something called a bounty. So effectively it will share some of the fine that it receives from a successful whistleblowing report with the person that made that report. Those bounties can run into the hundreds of millions of dollars. So there is a real incentive on people who've identified serious conduct to potentially share that with the US authorities. We don't have that in the UK, but it certainly, I think, has led to an uptick in enforcement that I know Chris and Matt are going to talk about, and an increasing focus on this. And I think probably I will just leave it there and then hand back.
Okay, thank you, Harriet. So yeah, let's talk just a little bit about we selected some cases, both under the FCPA, US FCPA, as well as the UKBA, cases that have been resolved in the last year or so that are very relevant for companies today, because they illustrate the current thinking of the enforcers. So let me first talk about some recent developments over the last few months pertaining to the FCPA in the eyes of the DOJ. So big changes happened last year with respect to this resource guide. The resource guide is required by statute in the US in order for companies to have an easy way to understand the FCPA and how the DOJ will apply it. So the resource guide is promulgated by both the DOJ and the SEC. It's available online, it's free, and it's updated pretty infrequently, only about every 10 years or so. So the last revision was last year. DOJ also released some new information about some new guidance and advice about how to run compliance programs. And we'll talk about that advice shortly in the presentation because it's very relevant for companies that have any concerns about DOJ FCPA enforcement. In general, last year, there was a decrease in FCPA enforcement actions, but still another record was set in terms of penalties. Every year, it seems that the DOJ and the SEC set new records on the sizes of the aggregate sizes of the fines that they collect. So almost over $2.75 billion in fines, US dollars, plus billions more collected outside the US by counterpart regulators. An important stat, 0 compliance monitors or consultants in FCPA cases. There was a time 20 years ago when DOJ would often impose a monitor or a consultant on a company at the company's expense in order to verify FCPA compliance. This was not well received by the international business community because you can imagine having a third-party monitor in your business, looking at your books and records, reporting back to DOJ about your compliance. Nobody wanted this, especially because you as the company would have to pay for it yourself. So DOJ has been ramping up the requirements for when it will impose such a monitorship. And the threshold now is very high. So DOJ and SEC rarely now require these monitors and didn't impose any last year. That said, the risk of getting monitorships in extreme cases still exists, and companies must do everything they can to try to avoid that additional expense. And then declinations. So declinations are when DOJ becomes aware of a potentially significant FCPA violation, but then decides to take no action. We'll talk very briefly about when it is that DOJ and SEC do a declination, especially in the context of the Toyota disclosure that was made several weeks ago. But basically, DOJ is likely to decline if a company cooperates with DOJ, discloses the FCPA violation to the agency, and then takes strong remedial measures to make sure it doesn't happen again. In those circumstances, a declination is highly likely. That's a high burden though, and we'll talk about why companies have to make a calculation about when to pursue a declination or when to simply not tell DOJ.
Interesting, and I hope that the reason that 2020 seems like the numbers were declined, nothing to do with the COVID-19 situation, but less companies do involved in bribery.
Yeah. It's a good question, PB. I would say, so, my experience is that, especially as a former prosecutor, FCPA cases usually take years to develop. So whatever happened in 2020 was in development probably beginning in 2017, 2018. So we see what we call lagging indicators with these enforcement actions. Let me skip ahead. Okay, so yeah, we talked about already declination. It requires usually you have to tell DOJ, you have to confess to DOJ, you have to cooperate, you have to remediate, and then you have to pay back any ill-gotten gains. These are very high thresholds. Many companies have to think hard about whether or not to take these steps or simply not cooperate with DOJ. It's a calculation that's difficult.
So sorry, can you go back to the former slide?
Sure.
Just one question, because we have seen few cases where companies voluntarily declare and then cooperate with DOJ. Does it mean that when DOJ decline to prosecute, meaning the company will be able to get around any fines? That's first question. Second question, would DOJ look how serious or how severe that action is?
Yeah, absolutely, PB. So to your first question, is declination, does that mean no fine? It does. So declination means nothing. In fact, not even a public disclosure of the FCPA investigation by DOJ. It's the cleanest exit. But to PB's second question, is a declination less likely in the circumstances of a severe violation of the FCPA? Absolutely. The bigger the perceived violation, and that's not only in terms of the size of the bribe, but also the size of the business that allegedly was acquired because of the bribe. So if I paid off an inspector 100,000 US and he gave me access to a $500 million contract, DOJ will say that's $500 million worth of corruption. And it'll be harder to get a declination in that circumstance unless I really take some very strong proactive steps to satisfy them. And as you know, this is a broader discussion, PB, but I will say that these four elements are difficult to satisfy, because when DOJ says full cooperation, they mean you have talked to everyone in your company about this possible violation. You've reviewed all relevant records. You've gone back 5 years worth of historical data. It takes years to develop an investigation that will satisfy DOJ to get to the point where they're comfortable with a declination. That's why it's difficult. Yeah.
I see. Okay, thank you.
Yeah, and actually this ties into some recent cases. So Matt, maybe we can ask you to talk a little bit about this famous 1MDB case in Malaysia with Goldman Sachs, a very recent and enormous fine from DOJ.
Absolutely, Chris, very happy to. And it was interesting actually hearing you talk about the declinature process and all of that sort of thing. All of that really came through in this case, or at least this case, I think, will help to emphasize why it is so difficult to persuade the DOJ to proceed on that basis, i.e. to decline to prosecute. So the 1MD affair is obviously very well known, particularly in the region. And the key headline issue here was that is really Goldman Sachs were obviously involved. And as a result of admissions they made regarding breaches of the FPCA, they were ordered to, or they agreed to pay $2.9 million. So that's a huge amount of money. So the key elements of the scheme were really this, was that they admitted that through two of their employees, that they essentially entered into a bribery scheme, and the benefit that they sought to derive through that was Goldman being appointed to have significant roles on at least 3 bond transactions that 1MDB, or pursuant to which 1MDB sought to raise capital. Now, an interesting issue regarding the admissions was that they admitted essentially that the control functions that they had in place did not operate sufficiently. So it was identified that although employees who were working in those control functions knew that transactions involving an individual at 1MDB, Joe Lowe, posed a significant risk, and that therefore they were on notice about those transactions and the problems that would arise from them. The control function essentially failed to take reasonable steps to ensure that Lowe was not involved. So they failed to protect the company in that respect. Goldman also admitted that there were significant red flags raised during the due diligence process and afterwards that they failed to identify, but also really failed to follow up on in that respect. With regards to mitigating factors, the department did find that there were a number of mitigating factors, but they weren't willing to give full credit for that. And one of the principal reasons was that the company had failed to voluntarily disclose its conduct to the department. The nature and seriousness of the offence was also a very significant factor. I mean, obviously, this is huge sums of money that are involved here, and huge identified breaches as well. So it was held that obviously the nature and the seriousness of the offence was a significant factor in terms of determining the degree of leniency that should be afforded. And it was, and in that respect, it related to the high-level employees within the company that were ultimately involved in, and their failure to really pick up on and to ignore and the red flags that has arisen, as well as the huge amount of money that was involved. The other issue as well and going back to Chris's point about the degree of cooperation that the department does tend to require, they found that there was really a problem with the cooperation that had been forthcoming. Largely because Goldman had failed to, or had significantly delayed in the production of relevant evidence. And that included recorded phone calls in which the company's bankers and control function had discussed allegations of bribery and misconduct and those sorts of issues. So whilst a degree of leniency was afforded, it only resulted in a 10% reduction in terms of the amount that would be required to be paid. So a very significant case, particularly for this region. Obviously, Malaysia is very close to Singapore and very close to Thailand, and really, I think, helps to emphasize the long-arm jurisdiction, or at least the long reach that the Department of Justice has when they're looking at these types of issues, but also, I think, illustrative of the types of things that will be taken into account as far as leniency is concerned. And as Chris mentioned, really this expectation that if you are going to cooperate with the department, then it is expected that that cooperation be full, that it be frank, and certainly that it be very prompt. Thanks, Chris. Back to you.
Yeah, sorry, since we are on this page, and given that the case is very publicly known, so a few questions or a few notices here. The name of Goldman Sachs. So this is the Malaysian subsidiary of Goldman Sachs US, right?
Correct.
That's interesting. And we are only talking about the DOJ. So I would assume that there would be a separate fine by the SEC.
I believe this PB was a global settlement, although we can check.
I see.
Yeah.
Okay.
But separately, as your viewers probably know, I believe that the Malaysian authorities also brought their own action against not only Goldman, but several other bankers directly. Yeah.
I know that they had to pay fines to the Malaysian government as well. It's quite an interesting case, and I even watched the movie.
Yeah.
Okay.
That's right.
Okay. Yeah, we can move, and I will have a question on the difference between deferred prosecution agreement and the plea agreement.
Absolutely. So PV, in the interest of time, I'll go quickly through some of the remaining examples. And this is actually, so the Alcon case is an example of a DPA, what we call a DPA, deferred prosecution agreement. So I'll just address briefly. In the world of DOJ, if you're a company under investigation, there's a range of outcomes. The best outcome for a company is the declination. You get a pass, there's no public filing, and you go home without paying any money. Above that is what we call the non-prosecution agreement, the NPA, which is DOJ requires you to make some admissions and undertake some affirmative obligations, but in exchange, DOJ says we're not going to prosecute you. The issue with the NPA is that it tends to be publicly filed on a US record for all time. So it's there for the world to see. Above that, is the deferred prosecution agreement, the DPA, which is basically an agreement, again, with some admissions given on the part of the company, and DOJ saying, if you play nice with me for the next 3 years, 5 years, whatever the period is, I will agree not to prosecute you. And again, DPAs are public. And then the worst case scenario is the guilty plea, because this is literally an admission that the company has violated US federal law. And that is what most companies very strictly want to avoid, is the guilty plea, even if it comes with a reduced fine, even if it comes with more favorable treatment. So the Alcon case is a case of a DPA. It's an example of a DPA. And I'll just say very briefly, in this case, the issue was that the company did not conduct adequate post-acquisition diligence. I'll just say briefly, if a US company or a company with the US that's considered a covered person acquires a non-US subsidiary, it has to check that entity to make sure that it is compliant with the FCPA. If it doesn't do a sufficient job checking the compliance of that entity, it may become responsible for what that entity does post-acquisition. So this is an example of a situation where DOJ said, you acquired a company, you didn't check it closely enough, they did violations of FCPA, and now you're the parent, you're in trouble. Any case, we decided to pick a couple of energy examples. In the any case, similar circumstances where the parent was held to have not closely enough supervised its subsidiary. What I think is important about this case is that the parent, was responsible for the violations of a 43%, right?
Chris, I think we've just lost your sound. Pick up and carry on. So I think the point Chris is making is that effectively this was a minority owned and controlled subsidiary. So the parent company, effectively was held responsible for a joint venture that it did not have the normal sort of full control over. And maybe if we can just go forward, and we might have Chris back.
Yeah, can you hear me, Harriet?
We can, thank you.
All right, thank you, Harriet, for picking that up. Yeah, and so Harriet's exactly right. That was the issue there, that even if you have a minority stake in a subsidiary, if there's a sufficient control, you may find that there's an FCPA issue. The Technic case I only pulled as an example because here the company did take remedial measures, did take enhanced controls to try to reduce the fine. But because of the severity of the offense, the fine was still very high, still almost $300 million in the end, despite the proactive response of the company. So that's the tension we were referring to earlier. I turn it to you, Harriet, for this example under the UKBA.
So I'm conscious of time, and we only have one UK example, but there are a few things I'd like to point out here. This is probably the largest investigation and deferred prosecution agreement the UK authorities have entered into. So it is a DPA. It effectively has a duration of 5 years. It means that Rolls-Royce will not be convicted of the charges in the UK, providing it complies with the terms, but it still had to make the guilty statement, as Chris had identified. And that's important for a number of reasons, one of which will be that effectively, if you admit guilt or you are convicted of a bribery offence in many countries, it prevents you from pitching for public contracts. It may restrict your ability to get financial services. It will be a very public matter that obviously then affects the reputation of the company and its ability to do business. So very much echo what Chris said. A couple of things I want to emphasize here. The scale of the conduct that was part of this DPA is really quite significant. So this related to payments made by 4 divisions of Rolls-Royce in 7 overseas markets over about 30 years. So what was quite interesting about this is actually the SFO, our prosecutor here in the UK, went to Rolls-Royce, identifying a specific issue in one country and said, we think you have a bribery issue, what Rolls-Royce committed to do was to not only investigate that issue, but actually to look at its entire business. It uncovered significant issues, but even though those issues were over a very long period, very significant, really quite egregious, the UK authority was happy to enter into a deferred prosecution agreement, which obviously, although it still involves the guilty plea, you know, relieves Rolls-Royce of certainly conviction of the offences because it had cooperated so fully. So in England, we'd say there's a carrot and a stick. I don't know how well that translates into Thai, but what you're really saying is, you know, although the authorities have very strict rules, there are opportunities that they can give companies to benefit when they have cooperated fully.
Yeah.
So the other thing I will just mention about this, although the size of the fine is really very significant, this is only the UK piece. So this was a coordinated settlement with the US and the Mexican and the UK authorities. The total payment that Rolls-Royce had to make was £671 million over 5 years. So that coordinated approach to settlements is again something we're seeing increasingly, but just to sort of emphasize both the scale and the size of the fines for these serious matters. And we can probably go forward, Chris.
Sorry. Can you just get back to the Rolls-Royce? I call it an inconvenient truth because it relates to Thailand with respect to Rolls-Royce in the UK. A few questions, and for the Rolls-Royce in the US that relates to our group company, and the case is also being investigated by the Thai NACC. But just a few points that people usually ask me. They usually ask, does it mean that we shouldn't do business with the company that has been under the compliance program after the DPA execution? What would be your advice?
So I think obviously every company will have its own rules and regulations about the risks and the reputation that it wants to put into the market. I think I will say two things. By the time a company has come out the other side of one of these investigations with a DPA, it has made significant investment in investigations. It can only get the DPA if it has fully cooperated with the authorities, and you would expect it to have dramatically changed the way that it does business going forward. So I think the risks of a company that has gone through this process, got a DPA in this public way, are very different perhaps from the company when the conduct was going on. But I think the reality is where you are doing business with a company that has had publicized issues in the past, you need to look quite carefully at how effective and how dramatic have been those changes. What I will say is we do have clients who have engaged with companies that have had historic anti-corruption. They have done enhanced due diligence, and generally those companies have been only too happy to explain how they have changed their business model, to provide evidence of it. You know, what you typically will see is far more focus on these issues in those companies going forward. So in some ways, you know, actually your risk may be lower. But I do think it's obviously from a reputation perspective, it's something you need to think about.
Yeah, I guess a good sample would be cement.
Yeah, absolutely. And there are other companies that have had well publicized issues that have come out the other side and continued to be great corporate citizens. So you just have to look at what's in front of you, I think, for that one opportunity.
Okay, thank you.
So I'll just talk very briefly about, in summary, what have we learned? What are some big takeaways from some recent resolutions? Very briefly, what is important is that there is some sort of mechanism in place to show that the company at a high level takes the compliance responsibilities, the anti-corruption responsibilities of the company very seriously. This is important because there's going to be scrutiny on that from DOJ and SEC in the event that there's an issue in our investigation. companies need to also make sure that they have policies in place for the M&A side. As we saw with the any resolution, it's important that there be a method for conducting diligence on new joint ventures, new collaborations, et cetera. And that extends to third parties. So in the interest of time, I do want to talk a bit about Toyota. So as we saw, Toyota disclosed several weeks ago that as of April of last year, in April of 2020, Toyota had reported itself to the SEC and DOJ with respect to anti-bribery violations related to a Thai subsidiary. Toyota said that it was cooperating with the investigation. Toyota admitted that the investigation could result in the imposition of a fine or other sanctions, and Toyota didn't have any further information. So two questions, of course, arise from this. Why is Toyota telling the world of the existence of this investigation? And why did Toyota tell DOJ and SEC last year that this was an issue? As to the first question, the reason why Toyota told the world is because Toyota was raising shares in a publicly traded market, and Toyota made this disclosure as part of its prospectus for that share offering, which requires under SEC regulations that the company indicate anything that could materially impact, right? Any factors that are known to the issuer that could materially impact the value of those shares in the near future. So Toyota made the decision that this investigation could materially impact the value of the company in the future. And that's because, as Toyota said, its investigation could result in a fine and other penalties arising from the investigation. So we can presume that whatever Toyota disclosed was relatively serious, and that there's an investigation in process that Toyota is taking seriously. Now, that said, we don't know anything else because Toyota is not required to disclose any more than that, and DOJ and SEC will not disclose any more than that. But that's what we know from the filings. Mm-hmm. The second question is, right. And so the second question is, why did Toyota tell DOJ and SEC? What was that? What was the purpose of telling them about this violation? And the reason is, as we discussed earlier, for companies that want to take full advantage of the safe harbors that come from declination, you must disclose early. You have to cooperate with the investigation. This investigation is likely to take many years if it's serious. And Toyota must have made the decision that it was better to get credit for self-disclosing to try to drive down any potential penalty, and that this outweighed the potential benefit of remaining silent. If Toyota gets a declination, we may hear nothing more about this, right? If Toyota is able to satisfy DOJ and SEC on those four factors that we discussed earlier, we may hear nothing more. But if there's any DPA, NPA, or other resolution, then we will learn more because DOJ will require some sort of admission and disclosure.
Right. On the first point, since I just had a session on IPO Thailand and beyond, and we also talk about offering under Rule 144A Regulation S, and we talk about disclosure opinion and things like that. So this is a part of the securities offering process that material information must be disclosed. And since we don't know more apart from what is written in this paragraph, so we won't comment on anything further. But as Chris said, there might be at least a good intention to disclose and cooperate with the authorities. Thank you. I know that the audience is looking to hear more about this, but this is so much we can talk.
Yeah, that's right. Thanks, PB. Yeah, so I think what the best we could do is offer up the experiences of similarly situated companies that have gone through this disclosure and cooperation process, and try to infer what it is that these companies often do. But yeah, otherwise the public record here is very limited. Because our time is also limited, I will turn it over then to, I will skip ahead a bit to Harriet to talk about compliance and what a good compliance program looks like.
Thanks, Richard. I mean, I was actually going to make a suggestion. On these next slides, we've summarized some of the public guidance on compliance programs, but why don't we go to slide 44, which summarizes those slides, and then I'm happy to speak to them. You or Matt may want to kind of sort of add in. But what we've tried to do on this next slide is really summarize what regulators around the world have told us, law firms and businesses, that they think makes an effective compliance program. And I think you can really cut it into these 6 pieces. The first point is that a one-size compliance program is no longer going to be considered to be effective. Just because a different business has a compliance program, adopting that same compliance program in your business may or may not be effective. You have to make your compliance program tailored to your key business risks. And that involves a hard assessment of the actual risks your business faces. So certainly in the UK, there is now an expectation that all sizable businesses will have an annual anti-bribery and corruption risk assessment that they will conduct annually, and they will track how the corruption risks their business are exposed to changes. Now, this can be quite a difficult thing to achieve, particularly if you are operating in an industry or a culture where speaking out against management is not considered to be good business etiquette or not considered to be appropriate. I've been doing this for quite a long time, and it would be very easy to become cynical about things that you see. But I fundamentally believe that a company's employees are its first, its best, its last line of defense. So if you can find a way to engage with your employees to help them understand that you are asking for their help in stamping out poor business practices, you will have a much more effective compliance program. They will tell you about the risks. They will share with you their concerns. Obviously, they then will need you to do something about it. So you have to be quite thoughtful about how you engage with people, how you escalate those issues. But I think having a program that's tailored to your most important risks is definitely an expectation. The other thing I would say, I'll maybe make 3 points and then hand over to Chris. What we call in English the tone from the top, the position that is taken by the most senior members of management and the board of directors is very important. It is no longer acceptable for a board of directors to say, well, the compliance team can do with that. We'll just get on with running the business. All of you are compliance lawyers now, which may be horrifying to some of you, but I think that's very much the way global regulators look at it. I have sat in meetings where global regulators, prosecutors have turned around to board directors and said, do you know how much your compliance program costs? And it's not necessarily something that will be at the fingertips of everyone. And that sort of neatly leads me into my third point, which is resourcing is becoming a key issue. So it is no longer, I think, to have a sort of what we would call a tick box, a sort of a form-based compliance program. What regulators are looking for is senior involvement, adequate resourcing, proper budgeting, and a compliance system that is able to say no to the business. And so one of the things that we've seen regulators increasingly ask for in the last few years is not the list of transactions that was approved, but the list of transactions that was declined. And what they want to see is that the compliance and legal function is able to say no to the business in the right circumstances. Matt, Chris, I don't know kind of which of these you would like to kind of add. I mean, it'd be interesting to know, particularly in Asia, how some of these things come out.
Why don't I just talk a little bit about my observations? I mean, all of them are becoming increasingly important, but I think that the issue is the ability to say no and the ability of the compliance team to really be heard. And I think that is one of the things that we have the greatest issue here, which is there's obviously a lot of pressure to be able to do and conduct business. And that pressure, so when somebody in the compliance team says, no, we can't do this or we shouldn't do it, then there can be a lot of pressure brought to bear by the business team. And I think it's quite clear that in those circumstances, you really need to have the support from higher up in the management chain and people in the higher echelons of management who are really willing to say, actually, no, this is a valid point. You've got to listen to compliance. We must put the brakes on, and we've got to look at it properly. And I think that is, I mean, it was evident in the Goldman Sachs issue. Everybody could see it, but nobody was saying no. And really that I think is the most challenging thing or the most challenging aspect in this region. But I also think it's the aspect that the regulators are most focused upon, because if your compliance team is not empowered and able to do its job, then you don't have a compliance team.
Right.
That's
what
very
I would,
clear.
yeah. And what I would emphasize is, we saw in Thailand for Thai companies, this promulgation of guidelines for internal control measures for companies. And these measures, if you look at these 8 measures that are highlighted on this recent guidance, track very closely the guidances that have been given to us by DOJ and SEC and SFO. You can see how they closely track strong policy support from top-level management, risk assessment, detailed measures for high-risk areas, accurate books and records, communication so that there is reporting and periodic review. As both Matt and Harriet said, the point is to sometimes test our compliance measures, test our internal controls to make sure that they are catching the right issues. The point here is that under Thai guidance, we're finding the same requirements, the same recommendations as we do from the other authorities.
Yeah, and for the benefit of the audience, we also have the Thai version. In fact, there are 4 languages: Thai, English, Chinese, and Japanese. And NACC has a pretty good resource on knowledge and guidance. So you can go to nacc.go.th for the information. And they have like the advisory service center in case companies or people do have questions. And in fact, this law, which came in 2018. So I would say that with the influence of the Rolls-Royce case, that forced NACC to come up with the sanction against corporates who receive the benefits, because previously under Thai law, we do have criminal offense on the officials who receive the bribes and also those who bribe, but never in the past that there's been any criminal offense on the company or corporate that's received the benefits. And it's also broad enough to cover, it could be an act by anyone related to the entities, could be employees, consultants, advisors, suppliers, and also affiliates, and that could be very broad. So turn to you.
Thanks, PB. Yeah, absolutely, and absolutely, as PB said, that's the trend with many jurisdictions now. It used to be that the penalties were directed towards the recipient. Now more and more authorities are targeting the giver, the giving party. So very briefly, we wanted to just talk a little bit about some anticipated developments on the US side. We'll just talk very briefly about it. As many of you know, the US just went through a presidential turnover in administration. And what that has generally signaled is that there's going to be increased enforcement from DOJ and SEC, particularly because President Biden's 2 picks to head these agencies have indicated that they want to take white-collar crime and corporate crime more seriously. So what we anticipate seeing is a continued focus on good compliance programs and proactive monitoring. We expect to continue to see cross-border information and enforcement. This is a trend that's started many years ago, but just seems to continue. And we expect to see a continued focus on multidisciplinary enforcement, so that there are multiple subject matters that are encompassed within an investigation. And I also want to stress that Gary Gensler, the new selection for the SEC chairman, has himself already indicated he wants to push for more aggressive enforcement of the US securities regulations and law. So in general, we anticipate seeing more enforcement activity from both of those agencies over the next few years. With that, I'll turn it over to see if Matt or Harriet have further comments, and then PB, we can go to you for any last questions.
Yeah, actually, there are two questions, but wonder if Matt or Harriet. Okay. So
nothing for me, thank you.
Yeah, let me read the question. Question one: if a company in Thailand is using Google or Microsoft service, both has server in the US, and it's violates anti-bribery books and record or internal control provision of the FCPA, does this mean the DOJ may bring a case against that company?
That's a great question, PB. So this is an open area. How tenuous, right, or how firm does the connection to US territory need to be in order to establish jurisdiction? I am not aware of a case where just using Gmail or just using a Microsoft suite product is going to establish US jurisdiction. And that's partly because, well, first, with both Google and with Microsoft, it actually might be hard for DOJ to conclusively determine that those communications pass through a US server, because those companies maintain servers around the world. And DOJ might perceive that kind of jurisdictional hook to be a bit too aggressive. They've been more open to extending their jurisdiction where US dollars are involved. So correspondent banks, US respondent banks. I haven't yet seen it with respect to electronic communications. Now, that said, they also haven't, I don't believe there's case law ruling that out. And so we could see that. We could certainly see, especially in a very egregious situation, prosecutors extending jurisdiction along those lines. Now, I will say that the internal controls and books and records requirements, again, will emphasize those only apply to US issuers. So unless you were a US issuer, you won't fall under the accounting provisions of the FCPA. You'll only fall under the anti-bribery requirement. But that said, as we've seen, internal controls, good compliance programs, these tend to be important beyond the US context anyway. So our general recommendation, of course, is have a good compliance program, because more jurisdictions than the US are going to be concerned about.
Thank you. Question two, for multinational companies, each country has its own law on prohibition on facilitation expenses or payment. What is the parent company's policy on this subject? Does its subsidiary should follow its parent company's policy, or it can establish its own policy if the relevant jurisdiction allows?
Shall I maybe sort of take that as a principle base, and then we can maybe talk a bit about the US? I mean, the idea of facilitation payments, so small, low value payments that are paid to public officials to smooth the path of normal business, the issue of a permit, the granting of a passport, something like that, are fairly controversial and have become more controversial. Some countries, noticeably the US, historically have recognized that those payments take place and do not obviously criminalize them. Some, such as the UK, take the position that all payments are bad and they should be criminalized. I think the trend is only one way, and the trend is only to excluding the ability to pay facilitation payments. Whereas when I started doing this, you might see individual country regimes that would have different approaches to facilitation payments in the policies. Now, typically the subsidiary will always follow the parent company, and the parent company generally will in most cases have a provision that facilitation payments are not permitted. There is one sort of exception to that most countries recognize, which is obviously duress, and that is where someone is kind of threatened with harm to make a payment. You know, there was a spate in some countries in Africa where, you know, people would be held at gunpoint to make these small payments for traffic offences. That kind of, I think, has largely died out. But I think generally the trend is very much against any company being able to pay facilitation payments and trend more to subsidiaries following parents. But I don't know, Chris, in the US, whether you've also seen that kind of same trend.
I would agree, Harriet. I think that, as you said, this has always been a controversial exception under U.S. law, and our general advice to clients is to not count on invoking the exception for facilitation payments if they have the choice, because it's very difficult. It's very difficult to anticipate how regulators or prosecutors will view those payments in the event of an investigation.
Okay, thank you. I think we come to an end. Although I like all of the slides, and particularly a few slides where I believe the audience can take that as like the key takeaways. I love the comparison table between FCPA and UKBA in particular, and a few slides where in fact it's highlights to the audience. Out of all this, we haven't talked much, but I know and the audience should be aware that reputation issue is something, I mean, you cannot compromise on that, because especially in this world of where the social media is everywhere, people can Google and see all negative news, and I do that all the times by having a due diligence session when we see negative news on our counterparties, and I also receive similar process or engage in similar process when people ask when they see negative news about us. So this is a very useful session, and I believe that not only lawyers but also the business companies can take this session as a good, I would say, training as well. And for any particular issue or fact or case, case is different case by case. So if you guys need to consult advisors, and like some of these questions where it needs to get to specific facts. So at the end, would you like to add on anything before I close the session today?
I'll just say very briefly, thank you all for your attention and time. It's been our pleasure to come before you.
Okay. Thank you, all of you, Harriet, Matt, and Chris from Jones Day for sharing this session with us and the audience in Thailand. I'm sure that they will find it to be beneficial to their way of conduct of business. And as you all said, I only see that the authority will be more and more strengthened and then enforced seriously. ESG coming up, and this is a part of the governance matter as well. So thank you, you all. Thank you, the Thai Listed Company Association, the Stock Exchange of Thailand, and look forward to seeing you all for the next session. ขอบคุณมากนะคะ สวัสดีค่ะ So goodbye.
Thank you.
Bye.
Goodbye.
Bye. Bye.